Joining me is Simon Jeans, a former member of the Refugee Review Tribunal and now principal of Jeans Lawyers, which specialises in immigration law. Simon, always great to catch up with you. How on earth did we end up with all these people that the government must now free from indefinite detention? I mean, have we been too slack in the kind of people we do let in and claim refugee status?
The people that we're talking about have often been in detention for over 10 years. So there's two groups of people we're talking about. The first group came in under Kevin Rudd's open border policy between 2009 and 2013, and that is the largest group of people. And so we really didn't have much choice. We couldn't screen them before they came because they came on boats. And at the time, it was before they were sent to Nauru, so they were processed in Australia. And then, as it turned out, they were found by ASIO to be threats to national security. You've got one person who was a member of the Egyptian Islamic Jihad organisation, which is a prescribed terrorist group. And then other people were released into the community but committed serious assaults. The case you referred to of the child rapist, which is the subject of the recent recent case, he came in, I think, in September 2012 on a boat. So you've got that group of people. Then there's another group which are coming in by visa and then engaging, such as a tourist visa or a partner visa, and then staying in Australia and engaging in criminal or terrorism activities.
But honestly, what do we do with these people? What should the government now do with this particular problem? These 80 people who, through the slackness of the Rudd government, came in without a screening, and now these others that you mentioned too. How do we fix this so that well, I don't know, you can't keep them in prison indefinitely. I guess the government should have planned for this in the first place, that you can't keep them there for 30 years, can you?
No, well, the system really started back in 1992. That's when the laws came in relation to mandatory detention, and that's been upheld by the High Court ever since last week. But there's lots of things the government can do to protect the community. So if they have to grant them a visa, they can put conditions on them, such as you have to reside in a particular place. And they could make that place Christmas Island. They could make it an uninhabited island where we build them a complete, refugee camp for them to live. There are a number of controls that we can have, but that's probably the main control. We can control where they live, so they don't have to necessarily move back into the main cities and just disappear among people or disappear amongst the community, because they'll simply be impossible to monitor. The police and security forces just don't have the resources to follow everyone. They can also pass legislation to say that if you have been unfairly detained, your maximum compensation is $1. So rather than pay out millions of dollars, as the Solicitor General foreshadowed, they can limit that. And that was done in the early 1990s with some Cambodian boat arrivals. They can also, what I would also do is I'd do a reassessment of their protection visa claims, because a lot of them may not be refugees, but the system that the Department of Immigration or Home Affairs uses is not what I would describe as particularly. It's not really good. It's pretty slack,
not
in
searching.
fact, and they accept a large number of people who are not refugees.
I love some of those ideas. But I tell you what, our refugee system has to also now start to include there's whole countries that are so safe, so democratic and all that. We don't accept any refugee claim from those countries, and just sort of end some of this farce. Simon Jeans, always great to catch up with you. Great ideas there. Thank you for your time.